Welcome to the Deep Dive. This is where we take complex topics, often based on source materials you provide, and try to give you a shortcut to being, well, genuinely well-informed.
And today we're doing a deep dive into a really fundamental area of human rights law, the rights of the child.
We're drawing exclusively on excerpts from a document that's been made available specifically for educational purposes.
Yes, and it's really important for us to acknowledge right at the start that this deep dive, our exploration of these key materials, is brought to you by Sinorbit Academy, Sri Lanka.
And the materials themselves were made available by the University of London. We must stress this is purely for educational use, designed to help you get to grips with this important subject.
Absolutely. And if you happen to be using this deep dive as part of your exam preparation, we really want to wish you the very best of luck.
Yeah, definitely. We hope this helps clarify things, maybe make some of the key concepts stick a bit better.
That's exactly our mission today. We want to be your guides through this source material. My role is to help synthesize the information, maybe connect some dots, and give context from the text.
And I'm here bringing the questions, the curiosity, ready to unpack the core principles, the legal frameworks, and, well, some of the really challenging realities we see when it comes to children's rights.
We'll be covering the main international convention, the mechanisms set up to oversee it.
Right, and then we'll look into some specific, often quite difficult areas that the text discusses, things like child labor, the issue of child soldiers, and how children interact with criminal justice systems.
And just to reiterate, we're sticking strictly only to the information presented in our source material for this deep dive.
Okay, let's get started then. So, children's rights. It's easy to think of them as maybe something separate, like an add-on to human rights.
Yeah, that's a common misconception, but the source makes it quite clear right away. Children's rights aren't some distinct category separate from human rights. They are, fundamentally, the application of core human rights principles, but specifically tailored to a group of children who are seen as needing special protection because of their vulnerability.
Ah, okay. So it's like the source mentions women's rights as a comparison.
Exactly. Think about women's rights. They take universal principles like equality and dignity and apply them with specific measures needed to tackle the historical disadvantages and particular vulnerabilities women face. Children's rights operate on a similar logic, applying those universal human rights, but focusing on the specific needs and vulnerabilities of children.
So why the need for this specific legal regime then? What makes children different in the eyes of the law?
Well, the source really highlights this. It comes down to inherent vulnerability and a lack of maturity compared to most adults. Children, generally speaking, lack the physical and mental maturity needed to protect themselves fully.
Yeah.
They're more susceptible to harm, to exploitation, to coercion. The text gives some pretty stark examples. Imagine putting a child offender through the exact same legal process as an adult.
They wouldn't understand it in the same way.
Exactly. They likely wouldn't have the cognitive grasp or the emotional resilience to navigate it effectively. Or think about armed conflict tragically. Children can be trained to use modern weapons, but their emotional immaturity makes them highly vulnerable to being forced into horrific acts or suffering deep psychological trauma.
And things like sexual abuse.
That's another critical area mentioned. Children face acute vulnerability to sexual abuse and exploitation, especially during times of conflict, instability, or extreme poverty. So all these factors together underscore why the international community decided that children need this specific detailed legal framework for protection, distinct from, but very much linked to, general human rights law.
So it's about applying those universal principles, but adding specific safeguards because of that unique vulnerability and dependence that comes with being a child.
Precisely.
The source mentions a bit of history, too. This international concern isn't brand new, is it?
No, not entirely. Even back in the days of the League of Nations, the UN's predecessor, there was international engagement with the Geneva Declaration of the Rights of the Child in 1924.
Okay, so early recognition.
Yes, and that concern definitely carried forward into the UN era. The Universal Declaration of Human Rights, the foundational 1948 document, specifically mentions in Article 25 that motherhood and childhood are entitled to special care and assistance.
Ah, Article 25 of the UDHR.
Right. And then the two big human rights covenants from 1966 also included provisions: the International Covenant on Civil and Political Rights, the ICCPR.
ICCPR, Article 24.
Yes, Article 24 says every child has a right to protection required by their status as a minor. And the International Covenant on Economic, Social, and Cultural Rights, the ICCR.
ICCR, Article 10.
Article 10 calls for special protection measures for children and young people. And there were other important steps, too, like the UN Standard Minimum Rules for the Administration of Juvenile Justice from 1985, often called the Beijing Rules. They focus specifically on how kids should be treated in the justice system.
But these were sort of scattered pieces, weren't they? Not one single, comprehensive, legally binding document just for children.
Exactly right. That was the gap. There was growing pressure from many different directions, governments, UN bodies, activists, for a single, comprehensive, legally binding treaty that would pull all these principles together.
And that led to the big one, the Convention on the Rights of the Child.
It did. A UN working group was set up, and the drafting process itself was quite long, about 10 years, which tells you something about the complexity and sensitivity involved.
A whole decade, wow.
Yeah, and what was really significant about that process, according to the source, was the role played by non-governmental organizations, NGOs. It was apparently the first time NGOs had such an instrumental role in negotiating a major UN human rights treaty.
Really, groups like Save the Children.
Yes, exactly. Groups like Save the Children were actively involved alongside governments and UN agencies like UNICEF, the ILO, the WHO. They brought that crucial on-the-ground experience and advocacy right into the drafting room.
That's quite a shift, having NGOs playing such a key role. And that long effort resulted in the 1989 UN Convention on the Rights of the Child, the CRC.
That's the one. Adopted by the UN General Assembly in November 1989, a landmark moment. And its acceptance was incredibly fast and widespread. It actually entered into force less than a year later, in September 1990.
And that speed and near universal acceptance is why it holds that record, right? The most ratified treaty.
Yes, exactly. The CRC is the most widely ratified international human rights treaty in history. The source notes that as of the end of 2016, literally every UN member state had become a party to it, except for just two.
Only two. Who were they?
The United States, which had signed it but cited constitutional issues preventing ratification, and South Sudan at that time. The fact that basically the entire world signed up speaks volumes about the global recognition of the need to protect children.
Yeah, that's genuinely incredible for an international treaty.
Yeah.
Now, the source points out something interesting right in the preamble about the family. It calls the family the fundamental group of society.
Yes, and this immediately brings up an inherent tension that the source flags, one that kind of runs through the whole convention. While the family is rightly affirmed as the primary place for nurturing and protection, the reality, as the source points out, and as we see in feminist critiques regarding women's rights in the private sphere, is that the family can also, sadly, be a site of oppression, abuse, or neglect for children.
Right, so the place meant for safety can also be the source of danger.
Exactly. It's a core difficulty the convention has to navigate. How do you support the family unit while also protecting the child within that unit?
And that ties into cultural values too, doesn't it? The preamble mentions taking into account traditions and cultural values.
Precisely. And as we know from other areas of human rights, problems often arise when long-standing cultural customs or traditions clash with universal human rights standards. Think about practices like child marriage or certain forms of discipline. What's culturally accepted might be seen as a violation under the convention. It's a constant challenge.
But children's rights have this extra layer, this unique vulnerability tied to their dependence.
Exactly. The preamble states it clearly. A child, because of their physical and mental immaturity, needs special safeguards and care. This fundamental reliance on adult carers, parents, guardians, the state, creates what the source calls a critical question. How do you make sure the carer doesn't become the abuser?
Given the power imbalance.
Right. Abuse is fundamentally about power imbalance. And tragically, as the source acknowledges, child abuse is a global problem, happening everywhere, across all societies and economic levels.
So the convention has to walk this tightrope. Support the family, but be ready to intervene. Acknowledge cultural context, but uphold universal rights. Recognize dependence, but prevent abuse.
That's the complex space it operates in, providing a framework that supports positive childhood development while having mechanisms to step in when protection fails.
Okay, that sets the stage really well. Let's dive into the specific articles of the convention itself. Part 1. Where does it start?
It starts with the most basic question. Who is a child? Article 1 gives us the definition.
Article 1, the definition. What is it?
It states quite clearly, a child means every human being below the age of 18 years.
Okay, so under 18. That seems straightforward.
That's the standard international definition used throughout the convention. Article 1 defines a child as anyone under 18. There's a small caveat. If a country's national law recognizes the age of majority earlier, that can apply within that country. But the general principle guiding the CRC is under 18. It defines childhood primarily by a lack of legal majority compared to an adult.
Got it. Article 1. Child means under 18. What's the next core principle?
Article 2 is absolutely fundamental. It lays out the principle of non-discrimination, a cornerstone of all human rights law.
Article 2, not discrimination. Like in other treaties.
Yes, but with a specific focus. It puts a double duty on states. They must respect and ensure all the rights in the convention for every child within their jurisdiction without discrimination of any kind.
What kind of discrimination?
It lists the usual grounds: race, color, sex, language, religion, political opinion, origin, disability, birth status, etc. But importantly, it also prohibits discrimination based on the status, activities, opinions, or beliefs of the child's parents or legal guardians.
So the child can't be penalized for who their parents are or what they believe.
Exactly. It connects back to that family context. Protecting the child means ensuring they aren't disadvantaged because of their family connections. So, Article 2 prohibits discrimination against the child, either directly or indirectly through their parents.
Okay, Article 2 prohibits discrimination. That's clear. Now, what about the principle everyone talks about with the CRC, the best interests of the child?
Yes, Article 3. This is arguably the heart of the Convention's philosophy. It states that in all actions concerning children, whether taken by public or private bodies, courts, administrative authorities, or legislatures, the best interests of the child shall be a primary consideration.
Article 3 establishes the best interests of the child as a primary consideration. Primary consideration sounds really strong.
It is strong. It means the child's well-being has to be a top factor in any decision affecting them. But, and this is a crucial nuance the source highlights immediately.
There's a but.
There is. Right after stating the principle, Article 3 qualifies it. It says decisions regarding protection and care must also take into account the rights and duties of his or her parents, legal guardians.
Okay. So it's not the only consideration. Parents' rights matter too.
Exactly, and this is where that potential conflict we talked about comes in. What a state agency or a court thinks is in the child's best interests might clash with what the parents think is best, or their perceived right to raise their child their way.
And defining best interests must be tricky.
Very. It's inherently contentious, culturally influenced. The Committee on the Rights of the Child provides guidance, sets a baseline, but the source notes that states still have considerable latitude in applying it. So remember, the best interest principle in Article 3 is primary, but it's qualified by and needs to be balanced against parental rights and duties.
Right. Article 3, best interest principle, qualified by parental rights. It's a balancing act. What about the state's duties to make sure things like schools or care homes are actually safe and adequate?
That's covered too. Article 3, Paragraph 3, gives states a positive duty to ensure that institutions and services responsible for children meet established standards, especially regarding safety, health, staffing, and supervision. And Article 4 elaborates on the state's overall obligation to implement the convention. For economic, social, and cultural rights, it says states must do so to the maximum extent of their available resources, potentially using international cooperation if needed.
Maximum extent of available resources. Does that give states an out if they're poor?
That's the potential loophole the source mentions. It's a standard clause in economic rights treaties, but it could allow a state to limit progress by pleading poverty. However, as we'll see later, the committee interprets this as requiring immediate steps and continuous improvement, not indefinite delay.
Okay. And Article 5 seems to circle back explicitly to the family again.
It does. Article 5 reinforces that the child exists within a family context. It requires states to respect the responsibilities, rights, and duties of parents, guardians, and even the extended family or community, to provide appropriate guidance as the child develops and exercises their rights. Again, children's rights are exercised within the context of the rights and responsibilities of those caring for them.
Let's group some of the next foundational rights. Life, identity, family care. Articles 6 to 10.
Right. Article 6 states the child's inherent right to life, a fundamental principle, but it adds a crucial dimension in paragraph 2. States must ensure, to the maximum extent possible, the survival and development of the child.
So not just preventing death, but ensuring they can actually thrive.
Exactly. It's a broader concept. Article 6 covers the right to life, survival, and development. Then Articles 7 and 8 deal with legal identity. Article 7 gives the right to be registered immediately after birth, the right to a name, a nationality, and importantly, the right to know and be cared for by their parents as far as possible.
Registration, name, nationality, parental care.
Yes. And Article 8 obliges the state to protect the child's right to preserve their identity, nationality, name, family relations. These rights can sometimes be qualified by national law, for instance, in complex parentage situations. So Article 7 and 8 cover identity, name, nationality, and registration.
And Article 12 links to this idea of the child's development, the right to be heard.
Yes. Article 12 is key. It guarantees a child who is capable of forming their own views the right to express those views freely in matters affecting them, and for those views to be given due weight according to their age and maturity. This includes being heard in relevant judicial or administrative proceedings. It's like a due process right for children in decisions about their lives.
Okay, now family separation, Article 9. This must be legally complex given the emphasis on family.
It is, and Article 9 lays out the rules carefully. The starting point is the state's duty not to separate children from parents against their will. Notice it focuses on the parent's will initially.
Right.
But then comes the critical exception. Separation is allowed when competent authorities subject to judicial review determine that such separation is necessary for the best interests of the child. This usually applies in cases of parental abuse or neglect.
So the best interest principle from Article 3 can override the parent's will here.
Yes, but only under strict conditions. Article 9 allows family separation if it's in the child's best interests, overriding parental will, but requires a decision by competent authorities with judicial review.
So there are safeguards.
Absolutely. Removing a child is a drastic step. It requires a decision by competent authorities. It must be subject to judicial review. A court can check it. And all interested parties, usually parents, maybe the child, must have a chance to participate. Article 9 also protects the child's right to maintain contact with both parents if separated, unless harmful, and requires the state to provide information if the separation is due to state action like detention. Article 10 deals with related issues when parents live in different countries.
What about Article 11 on illicit transfer? Abduction.
Article 11 requires states to combat the illicit transfer and non-return of children abroad. The source just flags this as a complex issue, mostly handled by other specific treaties, like the 1980 Hague Convention on International Child Abduction, so we won't dive deeper based on this text.
Fair enough. Okay, what about classic civil liberties, freedom of speech, religion, assembly? Are those in the CRC?
Yes, Articles 13 through 17 cover these, applying general human rights principles to children. Article 13 is freedom of expression. Article 14 is freedom of thought, conscience, and religion, importantly noting parental guidance consistent with the child's evolving capacities. Article 15 is freedom of association and assembly. Article 16 is the right to privacy. And Article 17 is the right to access appropriate information, especially from mass media, while also being protected from harmful material. So Articles 13 through 17 cover these core civil liberties adapted for children.
Articles 13, 17 cover civil liberties, and parents pop up again in Article 18.
They do. Article 18 recognizes the primary responsibility of parents for the child's upbringing, guided by the child's best interests. It also mandates state support for parents, including things like developing child care services.
Now, the source really emphasized Article 19, called it a core article. Why?
Because Article 19 is absolutely central to the Convention's protective function. It places a strong duty on states to take all appropriate measures, legislative, administrative, social, educational, to protect children from all forms of violence, abuse, neglect, maltreatment, or exploitation, including sexual abuse, while in the care of parents or any other caregivers.
So this directly tackles that risk of harm from carers we discussed earlier.
Exactly. It confronts that tension head-on and spells out the state's obligation to intervene even within the family when a child is being harmed. It provides the justification for state action under Article 9 when the home isn't safe. Article 19 is at the core of the Convention, focusing on protection from all forms of abuse and neglect, even by carers.
Okay. And what if a child is removed from their family? What protection do they get then?
That's where Article 20 comes in. Article 20 protects children deprived of their family environment. It outlines the special protection and assistance needed for children who can't stay with their families, covering alternative care options like foster care, adoption, placement in institutions, or kafala under Islamic law. It stresses that the child's background, cultural, ethnic, etc., must be considered when finding alternative care.
And there are specific articles for children in particularly vulnerable situations.
Yes. Articles 21 to 23 address these. Article 21 deals with adoption safeguards. Article 22 covers the specific protection needs of refugee children, and Article 23 addresses the rights of children with disabilities, emphasizing their need for special care and support for integration and development. So Articles 21-23 cover children in special situations like adoption, refugees, and disability.
That covers a lot of ground on protection. Let's move to the socioeconomic rights. Health.
Article 24 is the key one for health. It recognizes the child's right to the highest attainable standard of health and access to healthcare facilities. Article 24 is the core article on the right to health. It details specific state duties like reducing infant mortality, ensuring primary health care, combating disease and malnutrition, and providing pre-postnatal care for mothers.
And it mentions traditional practices.
Yes, crucially, Article 24.3 obliges states to take measures to abolish traditional practices prejudicial to the health of children. This is widely understood to include things like FGM and early marriage, even if not explicitly named here.
Article 25 seems related.
Yes, Article 25 concerns the right of a child placed in care for health reasons to have that placement periodically reviewed.
And Social Security.
Article 26 establishes the child's right to benefit from Social Security and social insurance. Article 26 concerns the right to Social Security.
What about just having enough to live on, a decent standard of living?
That's Article 27. It recognizes the right of every child to an adequate standard of living for their physical, mental, spiritual, moral, and social development. Article 27 establishes the right to an adequate standard of living. While parents have the primary responsibility, the state has a duty to assist them, potentially with material support like nutrition, clothing, and housing, and to help secure financial maintenance from parents.
Education must be a big one.
Absolutely. Article 28 is the core right to education based on equal opportunity. Article 28 is the right to education. States have specific duties. Make primary education compulsory and free. Encourage accessible secondary education, general and vocational. Make higher education accessible based on capacity. Encourage attendance and reduce dropouts. And ensure school discipline respects the child's dignity.
Does it say what education should teach?
Yes. Articles 29 and 30 cover the content and aims. Article 29 says education should develop the child's potential, foster respect for human rights, cultures, and the environment, and prepare them for responsible life in a free society. Article 30 protects the right of minority and indigenous children to enjoy their own culture, religion, and language. So Articles 28, 29, and 30 cover the right to education, its aims, content, and minority rights.
What about play? And the flip side, protection from harmful work.
Article 31 covers the right to rest, leisure, play, and participation in cultural life. Article 31 is the right to rest and leisure, and Article 32 is the crucial prohibition on economic exploitation. Article 32 prohibits economic exploitation. It protects children from work that's hazardous, interferes with education, or harms their development. States must set minimum ages, regulate hours and conditions, and enforce these rules.
The next few articles seem to cover other serious forms of exploitation. Drugs, sexual exploitation, trafficking.
Right. Article 33 requires states to protect children from illicit drugs and involvement in drug trafficking. Article 33 concerns protection from illicit drugs. Article 34 mandates protection from all forms of sexual exploitation and abuse, including prostitution and pornography. Article 34 prohibits sexual exploitation. Article 35 prohibits the abduction, sale, or trafficking of children. Article 35 prohibits trafficking, and Article 36 is a catch-all, protecting children against all other forms of exploitation harmful to their welfare. Article 36 is a general prohibition on other forms of exploitation.
What about kids who get into trouble with the law? Criminal justice.
Articles 37 and 40 provide key safeguards. Article 37 restates basic due process rights: no torture, no arbitrary detention, right to legal assistance, right to challenge detention. But it emphasizes that children should be treated as children in the justice system. It includes specific guarantees like separation from adults in detention, usually, and the right to contact family. Article 37 provides key criminal justice guarantees for children. Article 40 expands on these trial rights further.
And finally, the devastating issue of children in armed conflict.
Article 38 addresses this directly. In line with humanitarian law at the time, it prohibits recruiting children under 15 into armed forces or allowing them to take direct part in hostilities. Article 38 sets a minimum age of 15 for recruitment and direct participation in hostilities. Article 39 is broader, requiring states to help child victims of neglect, exploitation, abuse, torture, or armed conflict to recover physically and psychologically and reintegrate socially. Article 39 concerns recovery and reintegration for child victims.
Wow. Okay, that's an incredibly detailed list of rights in Part 1. Civil, Political, economic, social, cultural, specific protections. Covers so much.
It really is comprehensive, aiming for that holistic view of the child's life and well-being. And Part 2 of the convention then sets up the mechanism to actually check if states are doing what they promise.
Which is the Committee on the Rights of the Child.
Exactly. Article 43 establishes the committee. It's made up of independent experts, initially 10, now 18, who serve in their personal capacity, not as government representatives. Their job is to examine the progress states are making.
How do they do that? How do they monitor countries?
The main tool is the state reporting system, which is pretty standard for UN human rights treaties. It's laid out in Article 44. States that have ratified the convention have a legal duty to submit regular reports to the committee detailing the measures they've taken and the progress they've made.
How often?
An initial report is due within 2 years of the convention coming into force for that country, and then periodic reports every 5 years after that. Article 44 requires states to submit these regular reports to the committee.
So Article 44 requires states to submit reports. Do other groups get involved, like UNICEF or NGOs?
Yes, Article 45 is important here. It allows UN specialized agencies like UNICEF, ILO, WHO, etc. to be represented when the committee considers reports relevant to their work, and they can provide expert advice. Other competent bodies, including NGOs, can also submit information.
And what does the committee do with all this information?
Based on everything they receive, the state report, info from UN agencies, NGOs, Article 45 allows the committee to make suggestions and general recommendations. These often take the form of general comments, which are really important because they interpret the meaning of convention provisions in more detail. They can also make recommendations to the UN General Assembly. It's essentially a dialogue process.
The source mentioned the committee has a particular way of interpreting the convention, especially regarding socioeconomic rights and the links between different rights.
Yes, this is a key aspect of the committee's work described in the source. Remember Article 4, which talks about implementing economic, social, and cultural rights to the maximum extent of available resources?
Right.
The committee interprets this available resources idea as requiring progressive realization. This means the standard of rights enjoyment should continuously improve as a state develops economically, socially, culturally. But crucially, they argue, like in their general comment number 5, that this doesn't mean states can just delay action indefinitely. There's an immediate obligation to take concrete steps towards fulfilling these rights.
So it's not just a vague future promise.
No, they have to start now and keep moving forward. And connected to this, the committee strongly emphasizes the interdependence and indivisibility of all rights in the convention. They reject any idea that civil and political rights are somehow more important than economic, social, and cultural rights, or vice versa. They see them as completely interconnected.
A holistic approach. Can you give an example from their general comments?
Absolutely. The source mentions general comment number 3 from 2003 on children and HIV/AIDS. The committee pointed out that HIV isn't just a health issue under Article 24. It impacts everything. Well, children affected by HIV face discrimination, violating Article 2, challenges to their best interests, Article 3, threats to survival and development, Article 6, problems with family separation, Article 9, barriers to education, Article 28, risk of exploitation, Articles 32 through 36, and so on. The committee said the response must be guided by all the convention's general principles: non-discrimination, best interests, survival development, child participation, showing how these principles apply across the board in a complex crisis.
That makes sense. It's not just one article, it's the whole picture.
Exactly. Another example is general comment number 6 on survival and development, Article 6. They clarified that development means more than just physical survival. It includes mental, spiritual, moral, and social development in the broadest sense. This led them to discuss sensitive topics like adolescent sexuality and the need to address harmful traditional practices like early marriage, arguing that effective strategies must acknowledge the realities of young people's lives.
So they're pushing for a really broad, modern understanding of development.
Yes. And general comment number 7 on early childhood reinforced this holistic view. It linked Article 6, survival and development, to the critical early years, stressing the need for perinatal care, nutrition, psychosocial well-being, and protection from neglect and abuse right from the start. Crucially, they stated that the right to survival and development is implemented holistically through realizing all relevant convention rights: health, Art 24, nutrition, Art 27, social security, Art 26, living standard, Art 27, education, Art 28, Play, Art 31, and also through supporting parents, Arts 5:18.
It really paints a picture of the child's entire ecosystem of rights needing to work together.
That's the core message from the committee's interpretative approach, as described in the source. They take a progressive, holistic view, emphasizing that all rights are interconnected, which the comprehensive nature of the convention itself really facilitates.
Okay, so state reporting is one key monitoring tool.
Right.
What about individuals? Can a child or someone acting for them complain directly to the committee if their rights are violated?
That brings us to a more recent development. The original CRC, unlike many other major human rights treaties, didn't actually include a mechanism for individual complaints or communications.
Really, that seems like a major gap.
It was seen as one, while theoretically a child rights issue could maybe be raised before another treaty body, like the Human Rights Committee. The source notes this was practically difficult. Those bodies focus on their treaties, not specifically the CRC.
So how did that change?
It changed with the adoption of the optional protocol to the CRC on a communications procedure in late 2011. This protocol finally gave the committee the power to receive and consider individual complaints, making it the last major UN treaty body to get this function.
Why the delay?
The source suggests one reason might be that during the CRC's drafting, many states viewed it mainly as an economic and social rights treaty, and there was less initial enthusiasm for complaints mechanisms covering those types of rights compared to civil and political rights.
Interesting. Okay, so the 2011 optional protocol created this complaints mechanism. How does it work? Who can complain?
Articles 5 to 7 of the protocol lay out the rules. Article 5 says who can submit a communication: an individual child, a group of children, or someone acting on their behalf with their consent, unless justification is provided for acting without it, like if the child can't consent. The violation must concern a right under the convention or its two substantive protocols, sale of children or armed conflict, and the victim must be within the jurisdiction of a state that has ratified this specific communications protocol. So Article 5 covers who can submit communications, essentially victims or their authorized representatives.
Article 5 defines who can submit communications. What makes a complaint inadmissible, meaning the committee won't even look at the substance?
Article 7 lists several grounds for inadmissibility. Article 7 lists these grounds. Some are standard. It can't be anonymous, must be in writing, can't be an abuse of the process or incompatible with the convention. Also, the committee won't consider it if the same issue has already been examined by them or is being looked at by another international body.
And what about using the country's own courts first? That's usually a requirement, isn't it?
Yes, that's the critical admissibility rule in Article 70, the requirement to exhaust all available domestic remedies. You have to try the national legal system first.
Exhaustion of domestic remedies is required under Article 70. Are there exceptions?
Yes, important ones. This rule doesn't apply if using domestic remedies is taking an unreasonably long time, or if it's unlikely to actually provide effective relief. So if the national system is broken or too slow, you might be able to go directly to the committee. Exhaustion of domestic remedies under Article 70 is required, but exceptions exist for unreasonable delay or ineffectiveness.
Okay. Any other reasons a complaint might be thrown out?
A few others listed in Article 7, if it's manifestly ill-founded or lacks sufficient evidence, if the violation happened before the protocol came into force for that state, unless the violation continued afterwards, or if it wasn't submitted within 1 year of exhausting domestic remedies, unless there's a good reason for the delay. So Article 7 outlines all these admissibility criteria, including exhaustion of domestic remedies.
What if a child is facing immediate serious harm? Can the committee act quickly while the case is being considered?
Yes, and this is a very important power included in Article 6 of the protocol, the power to request interim measures. Article 6 covers interim measures. It allows the committee, in exceptional circumstances, to ask the state to take urgent steps to prevent possible irreparable damage to the child victim before a final decision is made on the case.
That sounds vital.
It is. The source notes this power is explicitly written into this protocol, whereas for some older treaties it developed more through practice over time. Interim measures under Article 6 can be requested to prevent irreparable harm.
Has this complaints procedure been used much yet? It's relatively new.
At the time the source was written, practice was still developing. Only one communication had been formally considered, and it was found inadmissible. The expectation is that the committee's approach will likely align with other UN treaty bodies over time.
And are the committee's decisions on these complaints legally binding?
It's not strictly. Article 11 says states should give due consideration to the committee's views and recommendations. This means they carry significant weight internationally, but aren't enforceable like a court judgment.
Does the protocol allow for anything beyond individual complaints?
Yeah.
Like states complaining about other states or the committee launching investigations?
Yes, it includes both. Article 12 provides for interstate communications, which is standard but rarely used in practice. More significantly, Article 13 sets up an inquiry procedure. Article 13 provides for an inquiry procedure.
An inquiry procedure, what's that for?
It's designed to address situations where the committee receives reliable information indicating grave or systematic violations of convention rights or rights under the two substantive protocols by a state party. It's for patterns of serious abuse, not just isolated cases.
How does it work?
The committee gets reliable information, invites the state to respond, and might then designate members to conduct a confidential inquiry. This could involve a visit to the country, but only with the state's consent. The process is confidential. The committee sends its findings and recommendations to the state, which then responds. The committee may then decide, after consulting the state, to include a summary in its public annual report. The Article 13 inquiry procedure targets grave or systematic violations, relies on state cooperation, especially for visits, and has confidentiality rules.
So it's a tool for major problems, but it depends heavily on state cooperation. And states can opt out.
Exactly. Article 13.7 allows states to declare they don't accept this inquiry procedure when they join the protocol. Article 14 allows the committee to follow up on what measures the state has taken after an inquiry. The source notes these provisions are the first time the monitoring section explicitly references the two substantive optional protocols.
Right. So besides this procedural protocol on communications and inquiries, the CRC has two substantive protocols dealing with specific issues.
Yes, and the source highlights this as quite unique. The CRC is unusual among UN human rights treaties for having two major substantive protocols in addition to the procedural one. The ICCPR, for example, has one on the death penalty, but not multiple substantive ones like this. It suggests states wanted to use the CRC framework to tackle evolving global problems affecting children.
Okay, let's look at the first one. The optional protocol on the sale of children, child prostitution, and child pornography from 2000. What's the context here?
12.4.1. This protocol addresses issues that, while sadly not new, have been transformed by technology and globalized crime. The source mentions the long history of child sexual exploitation, but highlights how the internet dramatically changed the scale and distribution of child pornography, making it a global crisis. It also talks about how trafficking, often by organized crime networks, has altered the landscape of child prostitution, with children forcibly moved across borders for exploitation.
It defines trafficking.
Yes, it uses the standard international definition involving recruitment, transport, or receipt of persons through coercion, abduction, fraud, or abuse of vulnerability for the purpose of exploitation, including sexual exploitation.
And it mentions sex tourism.
It does, a particularly grim phenomenon where adults, often from wealthier countries, travel specifically to exploit children sexually in places where they think they're less likely to be caught or punished, often due to weak law enforcement or corruption. Southeast Asia is mentioned as a historical example. The source also notes that some countries, like the UK, now have laws to prosecute their own citizens for child sex offenses committed anywhere in the world.
So the protocol requires states to criminalize these acts. But the source says Article 8 is particularly striking.
Yes, this is a key feature. Article 8 of this protocol places detailed obligations on states regarding how their criminal justice systems must treat child victims of these crimes. It goes beyond just punishing offenders. Article 8 addresses how child victims should be treated in the criminal justice system.
What does it require? How should victims be treated?
It sets out several duties. Recognize the child's vulnerability and adapt procedures accordingly, like for testimony. Recognize vulnerability. Inform victims about their rights and the legal process. Inform victims. Allow the victim's views and concerns to be considered. Consider victims' views. Provide appropriate support services throughout the whole process. Provide support services. Protect their privacy and identity. Protect privacy identity. Ensure safety for victims and witnesses from intimidation. Ensure safety. And avoid unnecessary delays in the legal process and in providing compensation. Avoid delay.
That's a very victim-centered approach.
Extremely. Article 8 also says uncertainty about age shouldn't stop investigations, reiterates the best interest principle for victim treatment, or 8.3, requires training for professionals, Art 4, and protects those involved in prevention rehabilitation, Art 5, while ensuring it doesn't prejudice the accused's fair trial rights, Art 6.
Implementing all that sounds like a major undertaking for states.
Definitely. The source calls these significant and onerous obligations, requiring potentially big changes to criminal procedures and investment in support services, which can be challenging for some states.
Okay, let's turn to the second substantive protocol, also from 2000, the optional protocol on the involvement of children in armed conflict.
12.4.2. This one, according to the source, has a much simpler core aim compared to the complexity of the first protocol. Its main goal is straightforward: to raise the minimum age for involvement in armed conflict.
So basically raise the age from the 15 mentioned in the main convention's Article 38.
Exactly. The context laid out in the protocol's preamble includes the devastating impact of conflict on children, the fact that modern weapons can make children effective fighters, and the reality that many conflicts today are internal. It references other standards, like the Rome Statute of the International Criminal Court.
What does the Rome Statute say?
The Rome Statute, which established the ICC, defines conscripting or enlisting children under the age of 15 or using them to actively participate in hostilities as a war crime. Under the Rome Statute, recruiting children under 15 is a war crime.
Okay, under 15 is a war crime. What age does this optional protocol aim for?
The protocol pushes the age higher. It requires states to take all feasible measures to ensure members of their armed forces under 18 do not take direct part in hostilities. It also requires states not to compulsorily recruit anyone under 18. For voluntary recruitment, the minimum age is generally 16, but with strict safeguards, and the push is towards 18. It also obliges states to criminalize the recruitment and use of under 18s by non-state armed groups. So the clear standard being promoted is 18. The minimum age for recruitment into armed forces and direct participation under the optional protocol on armed conflict is effectively raised to 18.
And the African Charter on Children's Rights also sets 18.
Yes, the source mentions the African Charter on the Rights and Welfare of the Child aligns with this higher standard, setting 18 as the minimum recruitment age. So you have the Rome Statute defining the war crime threshold at 15, but the CRC optional protocol in the African Charter pushing for 18 as the standard for recruitment and participation.
So the optional protocol sets 18 as the minimum for armed forces use, while under the Rome Statute, recruiting children under 15 is a war crime. That strengthens protections significantly.
It does. These protocols show the CRC system evolving to tackle specific major threats to children.
Yet, despite this incredibly comprehensive legal framework, the convention, the committee, the protocols, the source, is quite blunt in saying abuses are still widespread. It even suggests calling them just abuses of children's rights is maybe misleading.
That's a really important framing the source provides right before looking at specific issues.
Right.
It suggests that these violations, child labor, child soldiers, problems in juvenile justice, aren't just isolated acts of wrongdoing. They are often symptoms of much deeper structural problems.
Like what?
Like endemic poverty driving desperate choices, the chaos and breakdown of society caused by armed conflict, or fundamental challenges in national development that prevent states from building effective protection systems. Understanding this broader context is crucial for grasping why these abuses persist, even when they're clearly illegal under international law.
Okay, that's a vital perspective. Let's look at the first specific issue, child labor, 12.6. The numbers mentioned are staggering.
They really are. The source cites ILO and NGO estimates ranging from 250 million to maybe even 500 million children working in the developing world. Geographically, the highest numbers are in Asia, then Africa, then Latin America. Agriculture is the biggest sector globally, but it's also common in domestic work, trade, services, manufacturing, construction. It's widespread.
But the source is careful, like Article 32 of the Convention, not to condemn all work by children.
Right. Exactly. Context is key. Light work, helping the family, not interfering with school, not hazardous, that's different from exploitation. But the source quickly focuses on areas of major concern, the worst forms of child labor. It mentions examples like silk production in India, carpet and leather work in Pakistan, sugar harvesting in El Salvador. And it highlights bonded labor, dangerous conditions, and lack of freedom.
Let's focus on bonded labor, 12.6.1. The source calls it a key concern. Bonded labor is highlighted as a key concern. What exactly is it?
Bonded labor, or debt bondage, happens when a family takes an advance payment, basically a loan from an employer, and promises labor to pay it back. But the debt is structured through crazy interest rates, fake expenses, deductions, so it's virtually impossible to ever repay.
So they're trapped.
Completely trapped. The source lists industries in South Asia, Nepal, India, Pakistan, where this is rampant. Agricultural, brick kilns, carpets, domestic work, mining, manufacturing, the list is long.
And it can pass down through generations.
Yes, that's the most extreme form. It becomes intergenerational debt bondage, which is effectively slavery. Bonded labor, especially when inherited, is considered a form of slavery. A child can be born into debt incurred by their grandparents and forced to work their whole lives, often for no real pay, just to service a debt that never goes away. International law is unequivocal. This is slavery or servitude.
This isn't just kids helping out, it's actual enslavement.
Absolutely. The source calls it slavery reflecting extreme poverty. The child is essentially owned. It's linked to lack of income, yes, but also lack of access to credit, absence of social safety nets, adult unemployment. And crucially, it's worsened by discrimination against specific groups who lack social power and political voice.
And it becomes a cycle.
A vicious cycle. Children of bonded laborers usually became bonded laborers themselves. And the cheap bonded labor keeps adult wages low, making it even harder for families to escape poverty. It's tragically self-sustaining.
And the source explicitly links this to social structures like caste.
Yes, research shows bonded labor thrives where you have rigid caste systems and social hierarchies. It's described as endemic in South Asia, Nepal, India, Pakistan, Bangladesh. Bonded labor is strongly linked to extreme poverty, discrimination, and entrenched caste systems in South Asia.
So bonded labor is linked to extreme poverty, discrimination, and caste systems.
Hmm.
What's the international legal framework against this? You mentioned slavery conventions.
Legal framework reminder, yes, it's clearly illegal. The UN Supplementary Convention on Slavery, 1956, bans debt bondage. ICCPR Article 8 prohibits slavery and servitude. ICSCR Article 7 covers labor rights like fair wages and safe conditions, totally incompatible with bonded labor. And the ILO has key conventions. No. 29, forced labor 1930. No. 105, abolition of forced labor 1957. No on 38, minimum age 1973. And especially no on 182, worst forms of child labor 1999. Remember, ILO Conventions 29, 105, 138, and 182 are crucial against child labor, especially bonded labor and the worst forms. The source suggests checking the ILO website for more details.
Okay, let's use the India case study 12.6.2, 12.6.3 from the source to see how this plays out. The source presents India as a case study for child labor.
India is a party to these conventions, including ILO 138 and 182, though it ratified 182 relatively late, in 2017. The scale of child labor there is immense. Estimates often exceed 100 million. The source mentions Nobel laureate Kailash Satyarthi, known for his decades of work against child labor in India. Remember, Kailash Satyarthi won the Nobel Peace Prize for his work against child labor in India.
The source mentions a Human Rights Watch report, The Small Hands of Slavery. What industries did it highlight in India?
It showed that while agriculture is the biggest sector, around 64%, child labor is pervasive across many others. The source lists examples like silk, beady cigarettes, silver jewelry, gemstones, leather, carpets, diamonds, and also in services. Prostitution, restaurants, truck stops, tea shops, domestic servitude, it's really widespread.
So India has the laws, ratified the conventions, but the problem persists on a massive scale. Why does bonded labor persist in India despite laws and commitments? What reasons does the source give?
It points to a complex mix: structural problems, enforcement problems, lack of education, and deep-rooted poverty. More specifically, a lack of genuine political will despite official policies not translating into real action on the ground with proper funding. Monitoring bodies might not be effective. Then there's corruption and neglect of duty among officials.
And powerful vested interests.
Yes, a huge problem mentioned is that powerful feudal landowners and employers who benefit from cheap bonded labor are often politically connected, even holding office themselves, so they resist enforcement. There's a strong economic incentive to keep the system going. It's hard to hold high caste or local officials accountable. Bribery is described as endemic, undermining the whole system.
And the link to discrimination.
Absolutely fundamental. The source states the vast majority of bonded laborers are from marginalized groups, overwhelmingly Dalits or Muslims. Bonded labor in India disproportionately affects Dalits and Muslims. They lack power, are economically dependent, and face threats or violence if they try to complain. The caste system, while present elsewhere, is particularly entrenched in South Asia.
How has the CRC committee dealt with this in India's reports? India's party to the CRC.
12.sus.3. Yes, and child labor has been a constant theme. India's reports stress commitment and legislation, but a recurring issue highlighted by the committee and the source is India's federal structure. Power devolved to states makes enforcement of central laws inconsistent and difficult. India's federal structure is noted as a factor hindering consistent enforcement.
What did the CRC committee actually say in its concluding observations? Were they critical?
Yes, quite critical. The source summarizes their findings, CRC, ND, NDCO 3-4. They repeatedly express serious concern about the huge number of children in economic exploitation, especially hazardous work, mining, and bonded labor in the informal sector, domestic work, agriculture. The CRC committee has repeatedly expressed serious concern about widespread child labor, especially bonded and hazardous forms in India. They also noted a lack of reliable data.
What do they recommend India do?
Specific recommendations included speeding up a relevant bill, developing a comprehensive strategy with actual sanctions for employers, creating a proper database on child labor, and ratifying and implementing ILO conventions. They mentioned 138, 182, 189, 138, and 182 are now ratified. They also suggested technical help from the ILO. The source concludes that while India has made some legal progress, significant entrenched problems and interests remain a major barrier.
So the India example really shows how poverty, discrimination, corruption, lack of political will, and even state structure can undermine international law in practice.
It's a stark illustration of that gap between the law on paper and the reality on the ground.
Okay, let's shift to another incredibly difficult topic. Child soldiers, 12.7.
This is tragically a global issue. Children end up in armies or militias in various ways: abduction, force, but sometimes they join to escape extreme poverty or abuse at home, seeing the armed group as their only option for survival. Both boys and girls are used in combat, but girls are also frequently subjected to sexual slavery, used as wives. The source notes sexual abuse of boys is also increasing, but often goes unreported.
Where is this problem most acute, according to the text?
The source mentions parts of Africa historically, the Congo, DRC, Liberia, Sierra Leone, also groups like the Lord's Resistance Army in Uganda, and conflicts in Colombia, Myanmar, Lebanon, specifically the South Lebanon Army example.
The trauma these children endure must be unimaginable.
It is combat trauma, witnessing atrocities, often being forced to commit atrocities themselves, and a huge problem highlighted is what happens afterwards. Post-conflict, they're often just abandoned, no proper demobilization, rehabilitation, or psychological support. They remain traumatized, stigmatized, and peace agreements often completely ignore their specific needs.
Is there a legal framework against using child soldiers? The source confirms a legal framework exists.
Yes, definitely. We touched on it earlier. The CRC's Article 38 set the initial bar at 15 for direct participation and recruitment. But the optional protocol on the involvement of children in armed conflict from 2002 raised that standard significantly. Remember, the optional protocol sets 18 as the minimum age for recruitment and direct participation. Also, ILO Convention 182 on worst forms of child labor prohibits forced recruitment under 18 for conflict. ILO 182 also prohibits recruitment under 18. And critically, the Rome Statute of the ICC defines conscripting or using children under 15 in hostilities as a war crime. Recall, under the Rome Statute, recruiting children under 15 is a war crime. The African Children's Charter also sets the minimum age at 18.
So multiple layers of law trying to push the age up to 18, with under 15 use being an international crime. Let's look at the case studies. The source uses the Congo and West Africa as case studies. First, the DRC, case study. Congo, DRC.
Understanding the DRC requires understanding its devastating conflict, sometimes called Africa's First World War. The DRC conflict involved numerous countries. It started as a power struggle in the mid-90s, sucking in neighboring countries: Rwanda, Uganda, Burundi, initially supporting Kabila against Mobutu, then later Zimbabwe, Angola, Namibia supporting Kabila against his former allies. The human cost was immense, maybe 5 million deaths between 1997 and 2003, mostly from disease and starvation linked to the conflict.
And instability continues.
Yes. The source notes ongoing violence, rebellion, and a breakdown of government authority in large areas, allowing militias to thrive. The conflict in DRC is often linked to control over resources and ethnic tensions.
And everyone used child soldiers.
Tragically, yes. Child soldiers were used by basically all factions in the DRC conflict. Even the government army, FAC, reportedly still had them years later. Numerous militias like the Mai Mai, RCD-ML, UPC relied heavily on them. The UPC, led by Thomas Lubanga, later convicted by the ICC, notoriously used children as young as 7. Local defense militias used them, and intervening forces from Rwanda and Burundi also used child soldiers within the DRC. Demobilization efforts by NGOs, UNDP, UNICEF have occurred, but progress is slow given the scale.
Let's turn to West Africa, 12.7. Case study. West Africa, Sierra Leone, Liberia.
This region saw interconnected wars, particularly the brutal civil war in Sierra Leone starting in 1991, heavily influenced by Charles Taylor's Liberia. Peace has returned, but the legacies, including child soldiers, remain. The Sierra Leone Civil War and its legacies are key. A major step was the Special Court for Sierra Leone, a UN-backed court to prosecute those most responsible for atrocities. The Special Court for Sierra Leone indicted leaders partly for using child soldiers. It's now largely finished its work, with a residual court remaining.
And the source focuses on the Charles Taylor trial. Focus on the Charles Taylor case.
Yes. Taylor, former president of Liberia, was tried by the Special Court in The Hague. His charges included responsibility for militias using child combatants. Charles Taylor faced charges including responsibility for militias using child soldiers. His own forces recruited children, allegedly sponsoring small boys' units. Anti-government groups in both countries also used them extensively. Evidence described children fighting and carrying supplies.
What was the verdict on his involvement?
The court found he didn't directly command the Sierra Leonean rebels, the RUF, but he was crucial in supporting them by trading diamonds for weapons and fighters. The RUF were infamous for horrific atrocities, chopping off limbs and systematic recruitment of boys. The court ruled Taylor knew about these atrocities, including child soldier use, and by aiding the RUF, he shared criminal responsibility. Charles Taylor was found criminally responsible for supporting RUF rebels known for using child soldiers and atrocities. He got 50 years. Charles Taylor was sentenced to 50 years.
So supporting groups known to use child soldiers led to criminal responsibility.
Exactly. An important precedent. The source also mentions the ongoing challenges in Sierra Leone post-conflict, demobilizing thousands of child soldiers, lack of funding for reintegration, economic problems making reintegration hard.
What are the common factors we see across these cases of child soldier use?
Based on the source, conflict driven by resources or ethnic tension, state breakdown, used by all sides, state and non-state, recruitment through force or desperation, severe trauma, lack of reintegration support, and links to underlying poverty and social collapse.
A grim picture. Let's move to the final specific issue. Children in the criminal justice system, 12.8.
This section looks at how juveniles are treated when they come into contact with the law, mainly the criminal justice system. The core international principle is that the focus should be on rehabilitation and reintegration, not just punishment, recognizing children's different capacity and vulnerability. But the source states clearly that many countries still fall short, treating children like adults or using detention inappropriately.
What are the key international standards here?
The source highlights several UN instruments. First, the 1985 UN Standard Minimum Rules for the Administration of Juvenile Justice, known as the Beijing Rules. Remember the Beijing Rules for Juvenile Justice? Their focus is the child's well-being. They recommend proportionality in responses, considering the child's circumstances, not just the offense, especially relevant for status offenses like truancy. They also confirm due process rights.
What about kids who are actually locked up?
There are the 1990 UN Rules for the Protection of Juveniles Deprived of Their Liberty. These are the UN rules for protecting detained juveniles. They stress detention must be a last resort for the minimum period possible and detail conditions of confinement.
And preventing delinquency in the first place.
That's covered by the 1990 UN Guidelines for the Prevention of Juvenile Delinquency, the Riyadh Guidelines. Remember, the Riyadh Guidelines focus on prevention. They emphasize integration, positive activities, and a humanistic approach to understanding and reorienting young people away from crime. The Riyadh Guidelines aim for prevention and reorientation.
So the standards emphasize rehabilitation, minimum detention, prevention. But the source gives examples of major violations.
Yes, stark examples. Honduras. A 1998 UN report alleged police murdered hundreds of children. Later reports noted ongoing risks and security force involvement in deaths. So abuses in Honduras reportedly included police killing children. Guatemala. The Inter-American Court ordered measures against Guatemala regarding police murdering street children. Guatemala police were implicated in murdering street children. Paraguay. Reports of children held with adults in overcrowded prisons facing ill treatment like solitary confinement. In Paraguay, children were reported held with adults and ill-treated.
Horrifying examples. The source then uses Pakistan for a detailed case study. Now, a detailed case study. Farooq Ahmed v. Pakistan.
Yes, this case illustrates the complexities of implementing reforms, resistance, and cultural arguments. The case was pending before Pakistan's Supreme Court when the source was written.
What was the case about? A specific law.
Exactly. The case concerned the validity of the Juvenile Justice System Ordinance, JJSO 2000. It was adopted by a military regime, seemingly a genuine attempt to align Pakistan's laws with the CRC, but the source notes it lacked the investment needed to make it work properly.
What did the JJSO try to do? What were its key provisions?
JJSO provisions. It aimed for significant reforms, defined a child as under 18. JJSO defines a child as under 18, mandated free legal aid for accused children, state-funded, required separate juvenile courts, set different procedures, no joint trials of adults and children, assumed privacy in trials, different rules for arrest, bail, detention. Crucially, it prohibited certain punishments. No execution for crimes committed under 18, no hard labor, no fetters, no corporal punishment, limited handcuff use. Remember the key JJSO provisions: age 18, free legal aid, juvenile courts, no joint trials, and especially no death penalty for offenses committed under 18.
That ban on the death penalty for juveniles seems particularly important. How did the Farooq Ahmed case challenge this? Facts of Farooq Ahmed v. Pakistan.
Facts of Farooq Ahmed. Two people were accused of sodomizing and killing an 8-year-old boy. They claimed they were juveniles using school certificates. This meant they got JJSO protections, crucially avoiding the death penalty, common for such crimes. The victim's father, Farooq Ahmed, sued, claiming the accused were adults and arguing the whole JJSO was invalid. Farooq Ahmed challenged the JJSO validity after the accused claimed juvenile status to avoid execution.
And a high court actually agreed with him and struck down the JJSO.
Yes, the Lahore High Court struck down the JJSO in December 2004. The Lahore High Court struck down the JJSO in 2004.
Why? What were their reasons for invalidating a reform law like that?
Reasons of Lahore HC. Their reasons were quite something. They said Pakistan wasn't developed enough for the JJSO. They claimed a rights-based approach was inappropriate for Pakistan. They felt age 18 was arbitrary. They said parts were badly drafted.
And wasn't there a very strange argument about climate?
Yes, that's the most notorious reason. The court argued that poverty, hot climate, and spicy food in Pakistan lead to faster physical growth and maturity, so you couldn't have one age standard, 18 for all juveniles. This climate diet argument is widely seen as scientifically baseless and a form of cultural relativism, unsupported by human rights standards.
That's really something.
Any other reasons. They also said separate trials and different bail rules were impracticable. They worried about victims' rights being sacrificed for accused children's rights, and they claimed the JJSO was being abused by adult criminals faking their age and kids committing crimes knowing they wouldn't face execution.
So a mix of practical concerns, cultural arguments, and that very odd maturity claim. What happened after the High Court ruling? Did the JJSO disappear?
No. The Pakistan Supreme Court quickly suspended the High Court's judgment in early 2005. So while the case was pending final decision by the Supreme Court at the time of writing, the JJSO remained legally in force in Pakistan. The source also notes the huge practical challenges Pakistan faces: economic problems, conflict, refugees, population growth, making implementation very difficult regardless of the legal status.
Let's critique that Lahore High Court reasoning again. The rights-based approach isn't appropriate argument.
The source challenges that, noting Pakistan's own constitution has fundamental rights and Pakistan participates in international human rights standard setting. The court's view is described as strongly relativist. The court's argument against a rights-based approach is seen as strongly relativist.
And the climate diet causing faster maturity argument.
Completely rejected by the source. It has no basis in international human rights practice or credible medical science. The principle is, a child is a child everywhere, regardless of climate, diet, or wealth, entitled to protection under international standards the state has agreed to. Remember, a child is a child everywhere and entitled to protection.
So what is the real challenge to making the JJSO work in Pakistan, according to the source?
Real implementation challenge. The bottom line is this. The JJSO law exists, but it lacks the systematic institutional reform and committed resources to make it effective. Some parts are easy, don't execute, others are harder but feasible, different bail rules. But the big things: nationwide juvenile courts, truly free legal aid for all accused kids, which the JJSO mandates beyond even what the CRC strictly requires, a functioning probation service require massive, sustained investment and reform. Pakistan's economic situation makes this incredibly hard. Building these systems takes huge resources and time.
So it's the classic gap between passing a law and actually funding and building the system to make it real.
Precisely. The CRC committee itself noted these difficulties in 2016 when reviewing Pakistan, urging Pakistan to properly implement its obligations, specifically highlighting giving effect to the JJSO. The CRC committee urged Pakistan in 2016 to fully implement the JJSO.
This case study really pulls together the challenges: implementation difficulties, resource needs, cultural resistance, even if based on flawed arguments, potential for abuse, but ultimately showing that law needs infrastructure and political will to work.
It's a very telling example of the gap between aspiration and reality.
Okay, we've covered a huge amount: the convention, the committee, the protocols, and these tough issues like child labor, soldiers, juvenile justice, with detailed case studies. Let's try to tie it all together using that sample exam question the source provides. It asks, although the Convention on Children's Rights is described as the most ratified of international human rights instruments, abuses of children's rights are still widespread. How can this situation be accounted for?
That question really gets to the heart of the matter, doesn't it? The paradox between near-universal legal agreement and ongoing widespread violations. The source advises that answering this requires synthesizing all the reasons we've discussed for this gap.
So, pulling from everything we've covered, what are the key factors accounting for this gap?
First, the source points to the breakdown of civil institutions and rule of law, particularly in conflict zones. We saw that clearly with child soldiers in the DRC and Sierra Leone. When the state collapses, children become incredibly vulnerable.
Poverty was a huge factor in the child labor discussion.
Absolutely. Endemic poverty is a massive driver. It forces families into bonded labor in India, pushes kids towards armed groups for survival. It underlies many violations.
What about cultural resistance?
The persistence of cultural and economic patterns that resist change is key. Think of the caste system reinforcing bonded labor in India, or resistance to treating children differently in justice systems, as hinted at in the Pakistan case, or even reluctance to see the family as potentially harmful despite Article 19.
And the political will and resources point.
Crucial. Lack of genuine political commitment and failure to allocate resources are major blocks. We saw it in India's enforcement issues with child labor and Pakistan's struggle to fund the JJSO infrastructure. Without will and resources, laws remain symbolic.
The convention itself has internal balancing acts, too.
Yes. Balancing child rights with parental rights is complex, and applying universal standards across diverse cultures and development levels is inherently challenging.
So, to answer that question well, you'd need to weave together these factors: conflict, poverty, cultural resistance, lack of political will, resources, implementation complexity, illustrating them with examples.
Exactly. And you need to show the framework exists. Reference the CRC, key principles like best interests, Article 3, and non-discrimination, Article 2. Mention the committee's role, reporting, general comments, communications, inquiries. Refer to the protocols, exploitation types, armed conflict ages. Know the juvenile justice standards, Beijing rules, Riyadh guidelines. Then use the case studies: India, child labor; DRC, Sierra Leone, child soldiers, Charles Taylor; Pakistan, juvenile justice, Farooq Ahmed, to explain how those systemic factors undermine the legal framework. That demonstrates a full understanding from the source material.
This has been a really thorough deep dive into the rights of the child, sticking closely to our source material.
It has. We've gone through the UN Convention, its principles, the monitoring mechanisms like state reporting, the committee's approach, the communications and inquiry procedures, and then those tough realities of child labor, soldiers, and juvenile justice, using those specific case studies.
And it really does highlight that persistent, troubling gap between the legal commitments nearly every country has made and the reality for millions of children still facing terrible violations.
That gap remains the central challenge.
Well, thank you for joining us on this deep dive into the rights of the child.
Thank you. We hope exploring this source material has been useful for your understanding, especially if you're preparing for exams.
And as we finish, here's a final thought for you to reflect on based on our discussion. Given the almost universal ratification of the convention and the clear international standards, is the ongoing widespread abuse of children's rights primarily down to states simply lacking the resources and capacity, or is it more about a fundamental clash with deeply rooted cultural and economic structures, or perhaps mainly a lack of real political will, or maybe a complex mix of all these?
A tough question with no easy answers, but definitely worth thinking about.
Indeed. We encourage you to keep exploring this vital topic using the insights from this deep dive.